Thank you for joining Mayor Brown's webinar. Our program today will focus on preparing for the 2020 U.S. Proxy and Annual Reporting Season. I'll cover a few administrative items and then we'll get started. First, at the bottom of your screen, you will notice there are multiple application widgets you can use. All the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. Today's program is being streamed through your computer. For best audio quality, please make sure your computer speakers or your headset volume is up so you can hear the presenters well. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off your VPN is recommended. If your slides are behind, pushing F5 on your keyboard will refresh the page. You can find additional answers to some common technical issues located in the Help widget at the bottom of the screen. During today's presentation, you'll be provided with an alphanumeric code if you're applying for CLE credit. You will need this to record this code on the virtual sign-in sheet that you receive by email with the connection details. You'll also find a copy of the virtual sign-in sheet in the resource list widget entitled CLE Affirmation Form. Directions for returning the CLE affirmation form are on that sheet. We'll read the code in the middle of the presentation and then again at the end. Please note, we made the event evaluation form and presentation deck available in the resource list widget for your convenience. This webinar is being recorded as we normally do with these programs. In a day or so, we'll be sending you an email with a link which you can use to listen to the webinar again or share with your colleagues. The recording will also be posted on Mayor Brown's website. We plan to allow time at the end of the program for questions, so to submit electronically, please use the Q&A widget. If we don't get to your question during this webinar, we'll make every attempt to follow up with you after the webinar. My name is Laura Richmond, and I'm delighted to participate with my colleagues Anna Pinedo, Candace Jackson, and Ruchira Podali. Anna Pinedo is a partner and co-leader of the Global Capital Markets practice at Mayor Brown. She concentrates her practice on securities and derivatives. Anna represents issuers, investment banks, financial intermediaries, and investors in financing transactions, including public offerings and private placements of equity and debt securities, as well as structured notes and other hybrid and structured products. Candace Jackson, a corporate and securities associate in the Chicago office, advises public companies in connection with corporate governance and reporting obligations under the Exchange Act and the NYSE and NASDAQ rules. She has served both as in-house and outside counsel, most recently as Assistant General Counsel at U.S. Foods. Ruchira Podali is an associate in the corporate and securities practice in the Houston office of Mayor Brown. She represents public and private companies in mergers and acquisitions, securities offerings, and general corporate matters. Ruchira advises clients on securities compliance issues, including the Exchange Act. And my wide-range corporate and securities practice has a strong focus on corporate governance issues, SEC reporting obligations, stock exchange requirements, including proxy statements and related executive compensation disclosure matters, annual reports, board of directors, and Dodd-Frank and Sarbanes-Oxley compliance. So with that brief introduction, let's get started with today's program.
Thank you, Laura. Let's begin with Hedging Disclosure, which is a new requirement for the 2020 proxy season. In December 2018, the SEC adopted new Item 407I of Regulation SK, which requires issuers to disclose hedging policies and practices, specifically whether employees, including officers, and directors are permitted to purchase financial instruments or otherwise engage in transactions that hedge or offset or are designed to hedge or offset any decrease in the market value of the issuer's securities, and the specific categories of hedging transactions that are permitted and prohibited by the issuer's policies and practices. The SEC explicitly declined to define hedging, instead considering it to be a broadly applied principle that captures all transactions that are designed to establish downside price protection. The rule requires issuers to either disclose their policies or practices in full or to provide a summary, as long as that summary describes how the policies and practices apply to the covered persons and identifies the categories of permitted and prohibited transactions. Don't forget, officers are employees too, so if the issuer has a policy that only applies to its officers and directors, the issuer should disclose that hedging is generally permitted with respect to its other employees. The disclosure should also explain whether different policies apply to different classes of the issuer's securities. And if there's no written policy or practice in place, then the disclosure should disclose that fact. And alternatively, the company can state that hedging is generally permitted. Issuers are not required to disclose specific hedging transactions that have occurred. The focus here is on the issuer's policies and practices, not whether or not individuals have entered into specific hedging transactions. As far as timing and applicability of the new rules, accelerated filers and non-accelerated filers are required to include hedging disclosure for the 2020 proxy season. Smaller reporting companies and emerging growth companies are not required to include the disclosure until the 2021 proxy season, although there's nothing wrong with early compliance if smaller reporting companies and emerging growth companies are already including the disclosure in their proxy statements, as many companies are. Listed closed-end funds and foreign private issuers are not subject to the hedging disclosure rule, although the rule will apply to business development companies. Moving on to pay ratio disclosure. For calendar year companies, we've now seen 2 years of disclosure, which gives us both an opportunity to compare companies year over year and also an opportunity to see how the disclosures have evolved as companies apply lessons learned from year one. As a quick refresher, Item 402U of Regulation SK contains the pay ratio rule, and it requires issuers to disclose the median of the annual total compensation of all employees other than the CEO, and to compare that as a ratio to the annual total compensation of the CEO. The narrative disclosure should briefly explain the methodology that's used to identify the median employee and his or her compensation. So what have we seen for year two? Most companies disclose what is required, what's required by the rule, and not much more. This year, we've seen many companies taking advantage of the fact that they can reuse the median employee as long as there hasn't been a change in the employee population or in the company's compensation structure that would significantly change the ratio. We've seen some companies present the pay ratio for both 2017 compensation and 2018 compensation as an aid in comparing the two. And we've seen that the use of supplemental pay ratios is pretty consistent with year one. Companies that used them often did so to present a lower pay ratio when taking into account certain adjustments to CEO pay components or to exclude certain employee populations like non-U.S. employees or part-time and temporary employees. Common CEO pay adjustments included one-time or sign-on bonuses, annualizing multi-year performance awards, and excluding pension payments. There was pressure from institutional investors there was pressure from institutional investors last year to include supplemental disclosures about their median employees and about the employee population itself, but companies generally resisted including these supplemental disclosures. Companies with a global footprint were more likely to include supplemental disclosures, but where they did provide more information, it was generally to explain an unusually high pay ratio. There have, over the last few years, been a lot of developments in Cdna disclosure. It's really evolved over the last few years, going beyond the explicit requirements of Item 402, which including the objectives of the compensation program, what the compensation programs are designed to award, each element of compensation and why the company pays it, and how the amount of each element of compensation is determined. Today, we're increasingly counseling clients on ways to modernize the Cdna, making it more readable and user-friendly, and to help the company tell its story to institutional shareholders and ISS and Glass Lewis. Some common changes that we're seeing companies make include including a summary of or an overview of the Cdna at the outset that really hits the high points at the beginning, including a table of contents for the Cdna to allow the reader to more easily navigate the longer discussions, including an overview of company results, particularly when results are tied to performance-based compensation decisions, including a discussion of compensation issues that have been discussed with shareholders throughout the year as a part of the company's shareholder outreach, and how those issues have been addressed or are being addressed by the company. And companies are also rewriting the Cdna to put it into an easier to read format, using plain English, avoiding jargon, using graphs, charts, and other visual means of presentation, and discussing compensation realized versus amounts realizable. Say-on-pay proposal rules went into effect for annual meetings occurring after January 2011, so we're all pretty well versed at this point with the requirements. Issuers are required to include a say-on-pay proposal at least once every 3 years, with most companies voting annually, and they're required to allow shareholders to consider an advisory vote at least once every 6 years, where shareholders can determine whether they would like to consider a say-on-pay proposal every 1, 2, or 3 years. Most issuers obviously recommend an annual vote. A requirement of Cdna is that issuers are required to address whether they considered the say-on-pay vote in making compensation decisions, and if so, how. Some issuers include a negative statement that because the say-on-pay proposal received such high shareholder support, they made no changes in response to the vote. Otherwise, you typically only see disclosure when the proposal did not receive sufficient shareholder support and the company wants to explain what changes were made and why. As you can see from the data, the vast majority of say-on-pay proposals are overwhelmingly approved by shareholders. But for companies that have failed proposals or proposals that receive less than 70% approval, there can be consequences for board approvals and subsequent elections. So what can a company do if it's concerned about the vote or if last year's proposal was only narrowly approved? Well, the obvious option is to reduce compensation in future periods, but we all know that that rarely happens. More practical options would be to expand the rationale to how the compensation program ties to and supports shareholder value and strategic goals. This is particularly the case with performance-based compensation. Companies should consider providing additional information concerning historical pay, company performance, and shareholder returns in support of the compensation program. Companies can explain anomalies in compensation amounts. It's particularly important where there are, for example, periodic equity grants, but the amount all shows up in year one in the summary compensation table. This may be a reason to provide supplemental disclosure that smooths the impact out over the life of the grant. Companies can also reach out to shareholders as a part of their regular shareholder outreach, just to understand what their concerns are and to provide additional information or to actually make changes to the compensation program to reflect those concerns. Just keep in mind that during proxy season is not the ideal time to do this. Shareholders don't really have a lot of time to meet with companies during that time, so this should really be thought out in advance and be a part, like I said, of the company's regular shareholder outreach program. Companies can also highlight changes made from the prior year's compensation programs, even if they have not gone into effect yet. Disclosures such as, we made the following changes to the current year's compensation program that will show up in next year's summary compensation table and Cdna. Ideally, all of this is thought through and included in the proxy statement before it's mailed, but unfortunately, sometimes issues come up after the proxy statement has been mailed. And in that case, if the company wants to add additional arguments, don't forget about the SEC filing requirements and the need to file additional soliciting material. Finally, just a couple of things that are still on the radar. There are still a couple of Dodd-Frank proposed rules that still have no anticipated action date, and that includes compensation clawback policies and pay versus performance disclosure. In addition, interestingly, in April of this year, the Council of Institutional Investors petitioned the SEC seeking a rule change that would require companies to comply with Reg G in disclosing non-GAAP financial measures in Cdna, the same as what is required for earnings releases. So we'll keep an eye on that as well. I'm turning it over now to Laura.
Thanks, Candace. And rather than start with the basics, I'm going to start with what happened yesterday on Rule 14A8, which, as you may have heard, the SEC has proposed some amendments for comment. And what the amendments would do, first, it would change the ownership threshold for submitting a shareholder proposal. And now it would be, if the proposal goes into effect, a sliding scale, so that an owner of $2,000 worth of voting securities would need to hold them for at least 3 years to be able to submit a proposal, while an owner of $15,000 would only need to hold them for 2 years. And to get the 1-year holding requirement, the investor would have to have $25,000 worth of securities. And the proposal would not allow shareholders to aggregate their securities with other shareholders to meet this threshold. There would also be documentation requirements built into the rule for proponents who are submitting proposals through shareholder representatives. And the proposal would require proponents to be available to talk to the company between 10 and 30 days after submitting their proposal. And an interesting change is being made to the one proposal rule so that it will apply to each person, one proposal for each person instead of each shareholder. And this means the shareholder wouldn't be able to submit one proposal in the shareholder's own name and another as representative for another shareholder, or for a single person to submit 2 proposals to the company, one as representative of one shareholder and one of another shareholder. So that would be a significant change to the current practice. And the other thing that's getting a lot of publicity is that the proposed rules would change the resubmission threshold for exclusion, so that if a proposal, and this would be for proposals where the topic was voted on in the last 5 years. So if a proposal was voted on once before, it would be excludable if it got less than 5% of the vote. And if voted on twice, the threshold would be increased to less than 15%, while if there are 3 or more times for a vote, the threshold for exclusion would be if it got less than 25%. And there would also be a new type of exclusion for resubmissions, and that's if a proposal received less than 50% support and the support declined 10% from the last time it was voted on. Now, this is not going to affect the current proxy season. It's just, starting a 60-day comment period, which hasn't actually begun running yet. But it would be a good time to join the conversation because it's something that's out there, and the SEC is trying to decide what to do on it, and there's a lot of differences of opinions. I went over too many. I also want to talk about changes in the staff's procedure for reviewing Rule 14A8 no action letters. And that is that they're no longer going to respond necessarily in writing. There will be some responses that'll be oral and some will be in writing. And in some cases, the staff is going to simply decline to state a view. And this is going to leave companies in an uncomfortable position. They'll have to decide whether to move forward with the exclusion without the benefit of an SEC no action letter. The staff advised as part of its announcement of the procedure change that interested parties should not interpret its decision to decline to state a view as indicating that the proposal must be included in the proxy statement. But Glass Lewis has already warned that it will likely recommend votes against governance committees of companies that exclude proposals in that situation. So companies should start thinking about what they would do in this circumstance rather than waiting to decide once it happens. This slide highlights some of the proposal types that multiple companies received in the 2019 proxy season, and we may see some of these proposals raised again this year. Just want to mention with respect to diversity that the New York City Comptroller recently rolled out a new initiative asking companies to adopt a policy that would require the candidate pool for every open board and CEO position to have women and people of color included in the candidate pool. And the Comptroller did indicate that it will file shareholder proposals at companies that lack racial diversity at the highest levels. Now, most shareholder proposals don't achieve majority support, but this slide does provide examples of some that did during the 2019 proxy season, although not universally. But I want to also emphasize that minority support for a shareholder proposal can pressure a company to take some action, particularly if the minority support was a significant number of people approving the proposal. Shareholder proposal guidance from the last 2 years is going to provide some context for the staff's latest legal bulletin in this area. And I'll point out that slab 14I is the one that let us know that the staff would find a board analysis helpful for its determination of whether a proposal is excludable on either ordinary business or economic relevance grounds. And then last year in slab 14J, the staff addressed the board analysis that it had received that prior year under these bases for exclusion. And what I find most helpful about slab 14J is that it identifies 6 factors that the staff considers appropriate for a board analysis, and they're shown on this slide and the next one. This list isn't intended to be exhaustive, and it's not necessary for a board to address all 6 factors. But the list is useful because it offers a roadmap of what the staff finds helpful. So you should take it into account if you're preparing a no-action letter on one of these bases. We're going to skip ahead now so that I can talk about slab 14K, which came out in October. against the backdrop of what we saw over the last 2 years. And SLAB 14K emphasized that the staff takes a company-specific approach to the significant policy exception to the ordinary business exclusion. And that means if you're going to submit a no-action request on this basis, your analysis should be focused on the issues that the proposal raises in relation to your company. And SLAB 14K also elaborated on 2 of the 6 factors that the staff identified last year as appropriate to discuss in a board analysis. So if the company has addressed the proposal in some way other than what the proposal requests, the staff wants to see a discussion of the differences. This type of delta analysis is useful, for example, when the company steps don't qualify for substantial implementation exclusion because the company's approach to goals was different from what the proposal requested. And it can also be helpful where companies' actions have diminished the significance of a proposal to the company. And the SLAB 14K provided color on what the staff is and what it is not looking for in a discussion of prior shareholder votes on the subject. What the staff wants to see is a robust discussion that explains how the company's subsequent actions or intervening events impact the significance of the underlying issue to the company. SLAB 14K also emphasized that proposals involving the same subject matter can have different results on a micromanagement argument. And the key here is the extent to which the proposal prescribes specific actions for management of the board to take without giving them flexibility or discretion. And the key takeaway on this slide is that the board, that the staff is not impressed with overly broad technical readings of proof of ownership letters. And this slide is just a reminder that you should monitor your voluntary notice of exempt solicitation filings if they appear on the company's filing page. We've had those over the last couple of years, and companies really do want to know what's on their web page at the SEC on the EDGAR page, even though they don't have to do anything in response. But now I want to move over to the hot topic of proxy voting advice. And in August, the SEC issued guidance addressing some of the concerns that have been raised really for almost 10 years regarding proxy advisory firms like ISS and Glass Lewis. In fact, last week the ISS did sue the SEC, asserting that the guidance was unlawful and is seeking declaratory and injunctive relief. But for now, because it's an interpretation of existing law, that guidance is in effect. And a key point from this guidance is that the proxy voting advice provided by a proxy advisory firm constitutes solicitation under the proxy rules. And an impact of that is that the anti-fraud provisions apply to solicitations, even if there's an exemption from other proxy solicitation rules that a proxy advisory firm may rely on. And this means that proxy voting advice as a solicitation can't contain materially false or misleading statements or omit material facts. And this guidance went on to give examples of types of information that may need to be disclosed to comply with the anti-fraud requirements. And it is possible that the guidance being in effect this year, it may take proxy advisory firms a little longer to get their recommendations out. That'll remain to be seen. But yesterday, another thing that the SEC did was to propose amendments to the proxy solicitation rules to add conditions to the exemptions that proxy advisory firms typically rely on. This would, among other things, require disclosure of material conflicts of interest in proxy voting advice and not with vague or generic boilerplate. And under the proposal, proxy advisory firms would have to give companies, regardless of size, the opportunity to review and provide feedback on the proxy voting advice before it's issued, as long as the companies file definitive proxy materials at least 25 days before their meetings, which most companies do. The time period for review would be 5 business days if the filing of proxy materials occurred at least 45 days before the meeting. Otherwise, it would be 3 business days, and there'd be no opportunity for review required for companies that file less than 25 days before their meetings. The proxy advisory firms would not be required to make any changes, but keep in mind that they are subject to a no material misstatement or omission standard, so it would be risky if they simply ignore all feedback. And then after that review and feedback period, companies would have to get the final voting advice report 2 business days before it's issued to investors. And if the company requests, the proxy advisory firm would have to include a link in its report to the company's written statement of the company's views on the voting recommendation. The amendments would also codify some of the things from the guidance as in examples in Rule 14A9 as to what might be misleading and to codify when proxy advice is solicitation. There's a 60-day comment period for the proposal, and it contemplates that there would be a 1-year transition period after there are final rules. So it'll take a while before any amendments are in effect, but now is the time to join the conversation by submitting comments to the SEC. I do have a few slides on the investment advisor proxy voting guidance on proxy voting responsibilities, as well as on proposed rule changes to their advertisement and solicitation payments, which the SEC issued this week. And you can review those when you get the slide deck on your own. And with that, I'll turn the program over to Anna.
Thanks, Laura. And I'm going to talk about a number of themes that companies are going to want to consider in preparing their proxy statements as well as in preparing their 10Ks. And so the first of those Laura touched on a little bit, and that's sustainability, environmental, social, and governance disclosures, so ESG disclosures. And what has become pretty clear is that in recent years, both institutional investors have started to prioritize ESG issues and to insist on the need for more disclosure by companies, public companies, of ESG policies. And the proxy advisory firms, ISS and Glass Lewis, have also indicated in their policies that they're going to make voting recommendations that are based on ESG policies that are taken by companies. So this is still somewhat of an amorphous area, and I say that because, as we note on the slides, ESG disclosure may mean very different things to different constituencies. And so for some companies and for some industries, the focus is very particularly limited to climate change and how companies that are in particular industrial and manufacturing groups are addressing their greenhouse gas emissions. And in that regard, there is some guidance. So the SEC issued guidance on climate change reporting in 2010. If we go to the next slide, that guidance has been recognized as perhaps a bit dated at this point, and there have been a number of rulemaking petitions that have been filed seeking to have the SEC put forward a more comprehensive and a more standardized framework for ESG reporting by public companies, really acknowledging that the practices that public companies are using with respect to communicating their approach to ESG matters varies greatly, in part because, again, there's no single source that defines what the scope of ESG matters includes for different investor groups and institutional groups and funds and impact investors. They have particular interests in certain ESG issues, and again, that might be very variable across different industries and across different geographies, so there's really no uniform approach. Various commissioners at the SEC, including most recently Commissioner Peirce, expressed her views regarding some of the ambiguities insofar as what constitutes ESG disclosures and whether it's a topic that is material to every company or where there should be guidance or a specified disclosure framework. Most recently, an advocacy group called the Energy and Environmental Legal Institute filed a rulemaking petition this year, which they then supplemented, and they focus very particularly on climate change matters. So sort of stepping back, in a recent speech, CorpFin Director Bill Hinman noted that the SEC was going to continue, at least for the time being, with a principles-based approach to sustainability and ESG disclosure. So he both reiterated that the SEC's 2010 climate change guidance remained a good source to consult by public companies in preparing their SEC disclosures, but also went a step beyond that and noted that it was important as well for public companies in their disclosures not only to consult that climate change guidance, but to consider and disclosing and discussing the board's risk management role in the context of addressing climate change matters and sustainability matters. In the meantime, Congress has also gotten into the fray and has commented on ESG disclosures. There have been quite a number of bills introduced both on the House side and on the Senate side, and generally those bills would require that public companies enhance their disclosures of ESG metrics. So some of those bills are particularly focused on climate change, while others address more far-flung topics like having public companies disclose political contributions, lobbying efforts, and other matters. So if we go to the next slide, the proxy firms have codified their approach. So in preparing an annual report, in preparing the proxy statement, it's useful to look at both the approach taken by ISS and the approach taken by Glass Lewis to consider, in light of their publicly articulated views, whether it would be prudent for the company to address ESG oversight, which board committee, usually it's audit or risk, if there's a separate risk committee, has been charged with addressing ESG oversight and addressing it either in the proxy or the annual report. There are many companies that have chosen to take a different tack, and instead of addressing ESG issues in the context of their 10K or addressing ESG issues in the context of their proxy, often produce a separate or standalone report. Sometimes it's referred to as a sustainability report, a corporate social responsibility report. It's important to remember that claims that are made in these various reports, which usually are published on a company website or through some venue other than having them be publicly filed with the SEC, nonetheless can create liability and pose risks for the company to the extent that the company doesn't really implement the same rigor relating to the disclosures that are contained in those corporate social responsibility reports or sustainability reports. So the same process that the company undertakes with respect to producing and vetting 10K disclosure and proxy statement disclosure would be appropriate in the context of vetting these sustainability reports. Finally, there's been a proliferation of different reporting and rating agencies that have initiated for-pay and other matrices designed to measure or grade companies based on their perceived ESG policies. And so in producing any of these reports, it's also important to the extent that these metrics or standards are cited, that there's some balance to the way in which those are presented. So moving on, the other topic that is closely related, I'll say a close cousin, and has also attracted a great deal of attention of late, is human capital management disclosure. So again, somewhat amorphous. Here we have more specific guidance for boards to consider. The SEC's Investor Advisory Committee has made a number of recommendations to the SEC. Those are available on the SEC's website if you go to the page that is dedicated to the Investor Advisory Committee. And you'll see the various recommendations that the IAC has made to the SEC for requiring additional information on human capital. And so human capital would include or encompass things like a company's approach to recruiting personnel, to rewarding employees, to measuring productivity, to training and investing in the workforce. All of these different things, some of which may be measurable and susceptible to reporting metrics, and others that may be much more qualitative in nature. There have been various investor focus groups that have also put in to the SEC their own rulemaking petitions requesting that the SEC formally adopt prescribed disclosure requirements. And so among the disclosure requirements that the IAC in particular recommended the SEC consider working into Regulation SK are disclosures about a company's reliance on or use of part-time or contingent workers, how much the company spends or how the company thinks about training, diversity data for employees, so we're going beyond just board diversity and looking at the general workforce, data regarding turnover, how good is the company at keeping employees and keeping them motivated, and of course discussions on compensation plans and incentives. So some of that might be worked into proxy disclosure. It could be worked into separate standalone disclosures in reports that are not filed with the SEC. So some of this, the investor interest, the rulemaking petitions from the various groups, the recommendations of the IAC have found their way into some proposed changes that the SEC put forward this summer to the business section requirements of Regulation SK. And those request comment from the public. This is still a proposal. It is not final on various human capital matters. So while these aren't final, the large institutional investors care about this. It is likely that we will see some of these proposed new disclosure requirements be adopted. So it's certainly appropriate for boards to start considering and discussing how their companies would react to these disclosure requirements, perhaps to prepare for eventually having to disclose some of this information. Some of it may not be easily accessible or may require some time to gather. So this would be a very good opportunity to start pulling together a lot of this. Next, still on this broader theme of a company's role in the economy and more broadly a company's role in society, the latest statement from the Business Roundtable is this statement on the purpose of a corporation. So this purpose statement kind of presents a new vision of a company's role in society. So the longstanding premise, both from an economist viewpoint as well, a little bit in the core of Delaware corporate law, is that a board's role is to help management maximize shareholder value, and this statement of purpose is not inconsistent with maximizing shareholder value. However, it does also call upon boards to focus on other objectives in addition to maximizing shareholder value, or to think about shareholder value perhaps a little bit more broadly, as including things like focusing on long-term value creation. So abandoning short-termism, focusing on long-term value for the company and long-term investments for the company, thinking about things like company culture, thinking about how companies can invest in their employees, more broadly in the workforce at large, how companies can invest in and contribute or return to their communities. So there's been a lot of debate about this purpose statement. The purpose statement kind of, in my mind, fits into the continuing dialogue about short-termism and long-termism at companies, whether boards are appropriately focused on long-term investments and as opposed to focusing on managing earnings or thinking and living quarter to quarter. And so there's no direct change that results from this purpose statement. It doesn't alter in any way a Delaware corporation's board's duties under Delaware law. The duty of loyalty, fiduciary duties remain. But it does sort of force companies and boards to think about how they describe a company's strategic goals and strategic objectives in any presentation, including a 10K or a proxy statement. Moving right along, board diversity. As Laura pointed out, there's been increased pressure on boards to focus on diversity, and we see that through institutional investor voting policies, through ISS and Glass Lewis policies, which we show there on the slide. A number of bills introduced in this session of Congress that would require the SEC to adopt disclosure requirements that would call for more detailed disclosure on racial, ethnic, and gender diversity. So on the next page, next slide, we point out that certainly in advance of the proxy season, in anticipation of engaging with shareholders, in anticipation of the ISS and Glass Lewis recommendations coming out on company proxies, it's a good time for nominating and governance committees to review board composition, review the criteria that are used in evaluating director nominees, take a look at the self-assessments that the committee and that the board uses, and understand how those challenge boards to consider diverse director nominee candidates. As well, a practice pointer there to solicit information in this year's D&O questionnaires regarding the type of self-identifiable information on director diversity that a company can include in its annual report or proxy. And then, of course, in some states, we highlight on the next two slides, Illinois and California, there is legislation that imposes particular requirements. So the Illinois legislation, which is very briefly summarized on the next slide, doesn't require a particular number of diverse candidates to be included, but certainly requires much more detailed information. California, of course, was the first state to require a certain number of female directors. Now, as anticipated, this law has been recently challenged on very technical grounds in a so-called taxpayer suit. So we will see if the law stays in place. But at least in the meantime, it has served its narrow purpose of encouraging companies to recruit women. There are some additional practice pointers on Section 16 matters on the next slide. And another topic, again, of interest to the institutional investor community and proxy advisors is overboarding. So another topic that boards should consider and should consider addressing in advance of proxy season. So specifically, does the company's governance guideline and does the charter for the Nominating and Governance Committee require that the company consider how many other boards and what kind of time commitment is required from director nominees, and consider perhaps imposing limitations on the number of boards seats that a director can take. Finally, before I turn to Ruchira, critical audit matters. So most companies probably are already well in the midst of this. So critical audit matters are going to be added, and in some cases, for a number of companies, already have been added to the audit reports, and CAMs are intended to identify for readers of a company's financial statements those matters that are material to the company that involve subjective auditor judgment. So CAMs are required for large accelerated filers this year, for other companies starting after 2020, not applicable to emerging growth companies. We already have a certain number of companies that have implemented the CAMs requirements in their audit reports, and on slide 15, you'll see that the most prevalent CAMs that we've seen thus far include goodwill impairment, intangible asset impairment, certain revenue recognition matters, and the other topics that we list there. So certainly still time for audit committees to engage in active discussion with independent auditors about CAMs, to ask questions regarding how the CAMs disclosure included in the audit report might compare to the critical accounting policies that are included in a company's MD&A. In some cases, the CAMs disclosure might inform a company's MD&A, and in many cases, a company may want to understand the likely CAMs that are going to be included versus, for example, what they might expect to see from peer companies, and sort of anticipate and prepare their IR teams for questions that might emerge when year-end earnings and financial results are communicated. So I will hand things off to Ruchira.
Thank you, Anna. So recently, the SEC, in an effort to modernize and simplify certain disclosure requirements, has proposed several amendments. to Reg SK. And I'll be going through some of these amendments or proposed amendments affecting risk factor disclosure, certain simplification amendments, and Inline XBRL. So Item 503C requires disclosure of the most significant factors that make an offering speculative or risky. And effective May of this year, the SEC adopted a final rule that moved this risk factors disclosure requirement from Item 503C to Item 105, and this was done to indicate that it is applicable to a broad category of information and not just applicable to the offering context. As part of these amendments, the SEC also eliminated previously enumerated risk factor examples. So previously they had included examples of risk factor disclosure, for example, disclosing the lack of operating history or the lack of profitable operations, etc. But they've eliminated these examples to encourage registrants to think about the risk factor disclosure that may be more specific to their circumstances and therefore more meaningful to investors. In addition, recently in August of this year, the SEC proposed certain amendments to Item 105 in an effort to further discourage disclosure of generic risk factors. And comments to this proposed rule were requested by October 22nd. These amendments would require summary risk factor disclosure to be included if the risk factor section exceeds 15 pages. It would replace the disclosure standard from the most significant factors to material factors, and the rationale behind this was to limit disclosure to only those matters that a reasonable investor would consider when determining whether to purchase the security. And it would also require risk factors to be organized under relevant headings. And several companies already do this, but this might be a good time to revisit this particular aspect. Finally, the SEC also solicited comment on whether to require filers to order risk factors from greatest to least risk exposure. And the final rule for these amendments has not yet been adopted, but we'll continue to keep an eye on it. Moving on to certain specific categories of risk factors. LIBOR has been widely used as a benchmark reference rate, but recently, due to some issues, it is likely to be discontinued by 2021. The SEC has issued several statements emphasizing the importance of companies determining the exposure to a transition from LIBOR. And they've noted that the evaluation of these risks and mitigation of these risks might span several reporting periods, so companies during this time should provide their efforts to date and also address any significant matters that are yet to be addressed. And finally, they've also recommended that companies allow investors to see this issue through the eyes of management, and in that effort, it might be helpful to provide certain information that management is using to assess how to transition from LIBOR to an alternative reference rate. There are quite a few uncertainties surrounding Brexit, and so the SEC has been monitoring how companies have been evaluating their exposure to Brexit. So to the extent significant, Brexit disclosure should describe how it is expected to affect the company and its operations, and the SEC is looking for tailored risk factor disclosure regarding Brexit. Moving on to cybersecurity, in February of 2018, the SEC published guidance to assist companies with disclosure about cybersecurity risks and incidents, and in that effort, companies should consider disclosing prior cybersecurity incidents, probability and magnitude of a future incident, and which aspects of the company might give rise to such risks. In the trade area, companies should consider whether they need to update their risk factors to reflect any recent developments relating to tariffs or sanctions, and if they employ any foreign employees or consultants, you might also consider disclosing travel and immigration policies that might affect the company's business. In light of the various SEC amendments and the SEC's views on these trending topics, we recommend that companies tailor risk factors to the issues affecting the company at the time of filing of the annual report. So risks should be tailored not just to the company's own business, but also to the time of filing of the annual report. You should consider grouping risk factors into certain subcategories and removing risk factors that are generally applicable to other companies, but not quite as applicable to your company, or consider moving these risk factors to a generic section at the end of the risk factor section. Moving on to certain simplification updates. In August of 2018, the SEC amended certain disclosure requirements that it determined to be redundant or duplicative in light of certain other requirements or US GAAP, and these amendments have already gone into effect as of November 2018, so companies should already have experience with these rule changes. More recently, the SEC in May of 2019 made additional changes to the MD&A section and noted that a registrant may use any presentation that in its judgment it enhances a reader's understanding of its financial condition. In addition, the need to discuss the earliest year in a filing covering 3 years and the requirement to discuss 5-year selected financial data for trend information have both been eliminated. In addition, the SEC made changes to the property section Reg SK Item 102 in order to emphasize that the disclosure of principal physical properties need only be provided to the extent material to the registrant. The SEC has also made several amendments to Item 601, which is the exhibit section. Item 601B4 was amended to require the filing of an additional exhibit that would contain the description of the issuer's class of securities that are registered under Section 12 of the Exchange Act. And you might consider using a previous example that has already been filed with the SEC, but keep in mind that you might need to make some changes to the governance documents disclosure. Another change that has been made to Item 601B10 to allow the omission of confidential information from material contracts that are filed as exhibits without having to submit a confidential treatment request to the SEC. But keep in mind that such information should both be not material and should be likely to cause competitive harm if disclosed. In the same vein, Item 601B2 was amended to allow redaction of immaterial provisions in agreements relating to acquisitions, reorganizations, etc., that would likely cause competitive harm if publicly disclosed. And finally, a new paragraph, A6 of Item 601, allows companies to omit personally identifiable information from exhibits without having to submit a CTR. There have also been some changes to the cover page of the 10K. It must now include the trading symbol for each class of the registrant's listed securities. And once a company is required to use Inline XBRL, which is something we'll discuss next, information on the cover page of Form 10K, as well as on the cover pages of certain other forms, is required to be tagged in Inline XBRL. In addition, companies must now provide hyperlinks to information that is incorporated by reference if that information is available on EDGAR at the time the form is filed, whether or not that information is in a document that is filed as an exhibit as well. Moving on to Inline XBRL. In September of 2018, the SEC adopted amendments that would require the use of Inline XBRL for the submission of financial statement information. And Inline XBRL allows filers to embed XBRL data directly into the document that is filed on EDGAR. So you'll see that there's a difference in this kind of interface when you look at similar filings on Edgar. So here we show the phased-in compliance period that's based on filer status. As you can see, calendar year and large accelerated filers that use GAAP would have begun compliance with Inline XBRL with their second quarter 10Q. And keep in mind that even though there are other dates for the phased-in compliance period, companies can comply earlier. As part of these amendments, the SEC has eliminated the need for companies to post XBRL information on their websites, and this change has already gone into effect with the adoption of the rule, so you don't need to wait until your phase-in compliance period date. In addition, once companies are required to use Inline XBRL, they should also tag certain data on the cover pages of certain forms. And with respect to an 8K, even if there is no financial data involved, we need to include XBRL information on the cover page. Inline XBRL has also affected certain aspects of the exhibit index. So there is now a revision to item 101 of item 601 that requires that the exhibit index include the word inline within the title description for any XBRL related exhibits. So this would affect your 101 exhibits. In addition, an exhibit 104 needs to be added to the filing. One exception to this is if the only exhibit listed in an 8K exhibit index would be exhibit 104, which would be triggered by the need to include tagging information on the cover page. The SEC, through one of its compliance and disclosure interpretations, has specified that they will not object if the exhibit 104 is not included in such an 8K. And then finally, although there is a phase-in period for companies to switch to Inline XBRL, amendments to the cover pages of the various SEC forms have already gone into effect, just like the website posting requirement. And here we've shown a quick look at the changes that have been made to the cover page section. Companies should determine well in advance of their phase-in date exactly how they'll implement Inline XBRL. So if you plan to use an outside vendor, consider checking with them to see what they need to be in a position to embed the interactive financial data directly onto the documents on Edgar. And if companies are thinking about handling XBRL in-house, make sure that employees have received or will receive proper training on the new format. And at this point, there are several examples out there of companies that have already begun to comply with Inline XBRL. So those examples might be worth taking a look as well. And with that, I'll hand it over to Laura.
Thanks, Ruchira. That wraps up today's program. And so on behalf of Mayor Brown, thank you for your time in listening today. We hope you found this program useful. Be on the lookout for future invitations for programs that may be of interest to you. Thank you for participating. This concludes our webinar.